Tuesday, March 12th at 10 in the morning, I sat at the far end of a conference table in a probate attorney's office in downtown Columbus and listened to my sister inherit control of everything my grandmother left behind. The blinds were half closed. The room smelled faintly of carpet cleaner. Dana sat closest to the attorney, a leather folder already open in front of her. I had nothing on the table except my phone and a legal pad I never ended up using. When the attorney finished reading, he turned to Dana first. As executor, she would manage the estate account, oversee distribution of assets, and handle all financial decisions until probate closed. The brokerage portfolio, the certificates of deposit, the primary checking account, all of it fell under her authority. Then he turned to me. I was left the house in Chillicothe, a wooden structure built in 1948, vacant for 8 years. Roof issues noted in prior insurance inspections. Electrical updates incomplete. That was it. No shared authority, no co-executor role, no access to statements, just a deed to a property that hadn't been occupied since my grandmother moved into assisted living. My name is Lauren Whitaker. I'm 30 years old. I run a small interior design business out of Columbus. I pay my taxes. I keep my contracts clean. I have never missed a loan payment. None of that seemed to matter in that room. The attorney explained that the will on file had already been submitted to the Franklin County Probate Court 2 weeks earlier. Dana had opened an estate checking account the day after the funeral. All incoming and outgoing funds would flow through her. I asked one question. Had there been any amendments in the last year? The attorney checked the file in front of him. He said no. Dana didn't look at me. She kept her pen moving, making small notes in the margin of her copy. She had always been efficient like that, organized, controlled. After the meeting, she stepped into the hallway to take a call from someone at her office. She works in compliance for a regional healthcare system. Policies and oversight are her language. She sounded calm, already shifting back into her weekday routine. I stood by the elevator and reread the one-page summary the attorney had handed me. The Chillicothe property was described as sole, real property, interest, transferred to beneficiary Lauren Whitaker. Sole, it meant I owned it outright. It also meant I carried it alone. My grandmother had told me more than once that I was the only one who understood that house. I helped her repaint the kitchen cabinets when I was 22. I drove down on weekends to fix loose stair rails. Dana rarely came. She said the drive was too long. Yet the will placed Dana in charge of every liquid asset and left me with the one thing that required money to survive. Outside High Street was busy with late morning traffic. I watched Dana walk toward the parking garage without slowing down to see if I was behind her. By the time I reached my car, she had already texted me. "I'll handle the estate paperwork. You focus on the house." Handle. Focus. The structure was clear. She would control the accounts. I would manage the liability. That afternoon, I pulled the probate docket online. The case number confirmed what the attorney had said. The will had been admitted. Letters of authority had been issued to Dana. No objections filed. There is a window in Ohio probate law where beneficiaries can contest or request review. It is not indefinite. It requires cause. At that moment, I didn't have cause. I had a copy of a will and a property address 2 hours south of Columbus. I drove to Chillicothe the following Saturday. The house sat at the end of a narrow street lined with modest ranch homes and aging maple trees. The paint had peeled away in long strips. One shutter hung crooked. The yard had not been cut since late fall. I unlocked the front door with the key the attorney had given me. The air inside was stale but dry. Dust settled evenly across the hardwood floors. It wasn't a ruin, not yet, but it was close. I walked room to room, making notes the way I do for clients. Roof inspection, electrical permit history, foundation cracks, window seals, all of it cost money. Money I did not inherit. Standing in the living room, I tried to align the numbers in my head. My savings, a potential home improvement loan, the market value if fully renovated, the property taxes due in September. This wasn't about sentiment, it was about risk. If I sold it as is, I would take a loss. If I renovated, I would carry debt before seeing any return. Meanwhile, Dana would continue managing assets I had no visibility into. The imbalance wasn't emotional. It was structural. Before I left that afternoon, I walked out to the curb and spoke to the neighbor across the street, an older man who introduced himself as Mr. Halpern. He remembered my grandmother. He said someone had come by the previous summer to clear out paperwork. He assumed it was family. I didn't ask more questions. Not yet. Driving back to Columbus, I kept replaying one detail in my mind. My grandmother had always been precise with paperwork, bank statements stacked by month, tax returns clipped and labeled. She trusted documentation more than conversation. If she meant to leave everything exactly as written in that will, then this was simply her decision. But if she didn't, then the truth wasn't going to be in a conversation. It would be in a document. And right now, the only document on file gave my sister control and gave me a house that required money I did not have. I hadn't decided to challenge anything. I had only decided to look. The following Monday, March 18th, I took the morning off from client work and drove back to Chillicothe with a folder of contractor estimates and my laptop. The house looked different in daylight with purpose attached to it. Not sentimental, not inherited, just a structure with measurable problems. I started outside. The gutters were detached along the back edge. 2 shingles had lifted near the chimney. The exterior outlet on the side wall had no cover, which meant it hadn't passed inspection in years. I took photos of everything and uploaded them to a shared drive I use for projects. I labeled the folder with the property address the way I would for any client. By noon, I was inside moving room to room with a flashlight and a notebook. The breaker panel was original, cloth wiring in sections of the basement. The water heater bore a manufacturing date from 12 years ago. The plumbing was copper but patched. All of it was fixable. None of it was cheap. On the kitchen counter, I spread out 3 written estimates I had requested over the weekend. Roof repair, electrical update to meet code, basic drywall and flooring stabilization. Even the lowest bid pushed me beyond what I had in savings. That afternoon, I drove to my credit union in Columbus. It was a regular business day, no holiday closures. I met with a loan officer and applied for a home improvement loan based on projected after-repair value. They required a contractor's scope of work, proof of ownership, and a credit check. I provided the deed transfer from probate, which had been recorded in Ross County and was visible in public records. The loan officer confirmed that because the property was solely in my name, I could borrow against it without Dana's consent. That was the first time since the reading that I felt something shift even slightly, not in the estate, in my own lane. On Wednesday, I returned to Chillicothe to pull permit records at City Hall. The clerk confirmed that no renovation permits had been filed for the property in over a decade. There was no active stop work order, no liens. The house was dormant, not encumbered. Outside, I walked the block and knocked on the door across the street again. Mr. Halpern answered. He remembered me from the weekend. He said that last summer, a box truck had parked in front of the house for 2 days. 2 men carried out banker boxes and a metal file cabinet. He assumed my grandmother had asked for help clearing space. He did not recognize the men. He did remember that Dana had been there supervising. I wrote that down. It wasn't evidence. It wasn't an accusation. It was a timeline marker. Back inside, I checked the built-in cabinets in the dining room and the basement storage shelves. They were empty. Too empty for a woman who kept 30 years of tax returns in labeled envelopes. I had grown up watching my grandmother balance her checkbook at that same kitchen table. She saved appliance manuals, warranty receipts, insurance riders clipped together with notes in the margin. Yet there was no paper trail in this house. That absence was its own fact. On Thursday, my loan application was conditionally approved pending final appraisal. I scheduled a licensed general contractor, Mark Delaney, recommended by a colleague in Columbus, to meet me at the property the following Monday to walk through structural concerns before we finalized scope. He arrived on time, clipboard in hand boots, already dusty from another job. He moved methodically. Roof line first, then foundation perimeter, then interior framing. He pointed out water intrusion near the living room wall that likely stemmed from a past gutter failure. He recommended opening a section of drywall to inspect for rot before proceeding with cosmetic updates. I agreed. If we were going to invest in this house, it would be done properly. That evening, I emailed Dana to inform her that I had begun renovations and secured financing independently. I did not ask for permission. I did not request funds from the estate. I received a brief response hours later, acknowledging my message and reminding me that any personal property originally belonging to our grandmother technically remained part of the estate until final distribution. It was a precise reminder. The house was mine. What was inside it, at least in theory, might not be. The line between structure and contents had just become clearer. On Saturday morning, I stood alone in the living room looking at the wall Mark had marked with blue tape for inspection. The sunlight fell unevenly across the plaster. The floor dipped slightly near the baseboard. This was no longer just a renovation, it was an inventory, and I was about to find out what had already been removed before I ever received the keys. The following Monday, March 25th, I drove down before 8 in the morning to meet Mark and his crew. The appraisal for my loan had been scheduled for later in the week. Until then, every dollar I spent came directly from my savings. We agreed to open only the section of wall he had marked in the living room, no cosmetic demolition, just structural inspection. By 9:30, the drop cloths were taped down and the first cuts went into the drywall. I stayed inside, not hovering, but present. It was my property, my liability. When the panel came loose, nothing dramatic happened. No immediate collapse, just a section of insulation that looked denser than the rest. Mark stepped closer. He ran his flashlight along the cavity between the studs and paused. There was a second backing panel behind the first cleaner, newer lumber than the original framing around it. He stopped the crew and called me over. The space between the two layers wasn't large, but it was intentional. Someone had constructed a shallow compartment and sealed it shut before replacing the outer drywall. We documented it with photos before touching anything further. Mark recommended we proceed carefully in case it involved wiring or structural bracing. When the inner panel was pried loose, a metal object became visible behind insulation wrap. It was a small lockbox, rectangular, no larger than a legal-size envelope, wedged between studs and secured with 2 screws driven into a wooden brace that had been added later. It had not fallen into place accidentally. Mark stepped back and asked how I wanted to proceed. The house was in my name, but because the estate was still open and because my sister had already reminded me that personal property could technically fall under estate review, I made a decision I hadn't expected to make. I asked Mark to pause and called the Chillicothe Police Department's non-emergency number. I explained that I was the legal property owner, that a sealed container had been discovered inside a wall during permitted renovation work, and that I wanted documentation of its condition before opening it to avoid future disputes over ownership or contents. An officer arrived within 20 minutes. He reviewed my deed copy, which I had printed in my project folder, and confirmed that the structure belonged to me. He made clear that if the contents were not contraband and no immediate criminal issue was evident, the matter would be civil, not police enforcement. He photographed the lockbox in place before it was removed from the wall cavity. Mark unscrewed the brace carefully and handed the box to the officer for inspection. There were no markings on the outside beyond a basic combination dial. No name, no label. The officer asked if I intended to open it. I said yes, but only after it was documented. He recorded the serial number stamped on the underside and noted the condition of the drywall cavity. Then he stepped aside and stated clearly that opening the box was at my discretion as the property owner. My hands were steady when I set it on a folding table in the dining room. I tried one combination first, my grandmother's birth year. It did not turn. I tried the street number of the house. Nothing. Mark stood a few feet away. No one spoke. Then I entered the month and year she had moved into assisted living. The dial clicked. The lid lifted without resistance. Inside were 3 items: a folded document clipped together with a small notary seal attached to the last page, a stack of bank statements bound with a rubber band, and a sealed envelope with my name written in my grandmother's handwriting. The officer leaned slightly forward but did not touch anything. I unfolded the first document. It was a will, dated 6 months before her death, signed, notarized, witnessed. The distribution was not the same as the version read in Columbus. I did not read further out loud. I did not need to. The officer asked if there appeared to be anything requiring immediate law enforcement action. I said no. He completed his incident report, gave me a copy of the report number, and left. The house felt different after that. Not emotional, not vindicated, just altered. Mark asked whether I wanted to continue demolition. I told him to stop for the day. I placed the documents back inside the lockbox and carried it with me when I locked the front door. For the first time since the reading, I wasn't holding a question. I was holding a contradiction, and contradictions have timelines attached to them. I did not sleep much the night I brought the lockbox home. On Tuesday, March 26th, I called a probate attorney in Columbus whose name I found through the Ohio State Bar referral directory. Her assistant scheduled me for a consultation the next afternoon. I scanned the will, the bank statements, and the sealed envelope, but I did not open the envelope yet. I wanted a witness to that decision. Wednesday at 1:30, I sat across from attorney Melissa Grant in a modest office near the courthouse. I placed the lockbox on her conference table and removed the documents one by one. She began with the will. It was dated September 8th of the previous year, 6 months before my grandmother's death. The notary stamp was from a branch bank in Ross County. 2 witnesses had signed both names printed clearly beneath their signatures. Melissa compared it line by line with the copy of the will already admitted to probate, which I had obtained through the county's online docket. The distributions were not the same. In the document found in the wall, the brokerage account was to be divided evenly between Dana and me. The certificates of deposit were to fund a small educational trust for 3 of my younger cousins. The house remained mine. Dana was not named executor. A local bank trust department was. In the version admitted to court, Dana was sole executor and primary beneficiary of all liquid assets. The educational trust provision was absent. Melissa did not speculate. She asked for dates. The will on file had been executed in December, 3 months after the one in my hands. Under Ohio law, the most recent valid will controls, assuming it was properly executed and not the product of undue influence. We reviewed the notary seal on the September document. It matched a real commissioned notary whose information was searchable through the Secretary of State database. The witnesses were not family members. Their addresses were listed. Melissa requested copies of both wills and asked me to authorize her to obtain the probate file directly from Franklin County. Then she turned to the bank statements. They covered a 4-month period leading up to my grandmother's move into assisted living. 2 transfers stood out, both labeled as reimbursement, both directed to Dana's personal account. The amounts were substantial enough to matter. Melissa circled the dates. One of the transfers occurred during the week my grandmother was admitted to a long-term care facility in Chillicothe. She asked whether my grandmother had granted Dana power of attorney. I did not know. Melissa explained that as executor, Dana had a fiduciary duty to the estate and to all beneficiaries. If funds were transferred without proper authority, that was not a disagreement. It was a breach. She recommended filing a petition to reopen review of the admitted will and requesting formal accounting from Dana in her capacity as executor. That was not a small step. Once filed, the court would notify Dana. She would have to respond. I sat there for a moment before signing the representation agreement. This was still my sister. Melissa drafted a preliminary letter that afternoon notifying Dana that new testamentary documents had been discovered and that a petition would be filed within the week. I left the office with a copy. In the parking garage, I finally opened the envelope with my name on it. The letter was brief. My grandmother's handwriting was steady. She wrote that she had changed her will in September because she believed Dana was under financial pressure at work and might make decisions too quickly. She stated that she wanted an independent trustee to oversee distributions to prevent family conflict. There was no accusation in the letter, no dramatic claim, just a preference for structure. That night at 8:47, Dana called. I let it go to voicemail. Her message was controlled. She said she had received notice from an attorney claiming another will existed. She asked where I had found it and whether I understood the seriousness of interfering with probate proceedings. I did not return the call immediately. By law, the court would schedule a hearing. By law, the court would schedule a hearing date. The matter was no longer contained inside a wall. It was now on record, and once something enters the record, it acquires weight. The court's notice arrived the first week of April. A hearing date was set for mid-May to review the December will and consider the September document we had submitted. Until then, Dana remained executor. That detail mattered. As executor, she still controlled the estate account. She still had authority to pay bills, reimburse expenses, and communicate with financial institutions on behalf of the estate. Melissa advised that we formally request a complete estate accounting under Ohio probate rules. Executors are required to document all receipts, disbursements, and distributions. It was not an accusation. It was a procedural right. The request was filed on April 4th. Dana was given a deadline to submit itemized records of all transactions since the estate opened. 3 weeks later, we received the accounting. It was organized. Clean spreadsheets, dates, amounts, memo lines. She had always been thorough. Most entries were predictable. Funeral expenses, property taxes, utility payments for the Chillicothe house before title transferred. Then there were 2 entries labeled reimbursement for care coordination. Both were transfers from my grandmother's personal checking account in the months before her death. Both directed to Dana's individual account. The combined total exceeded what I would need to complete the initial renovation phase on the house. Melissa compared the dates to the bank statements found in the lockbox. They matched. One transfer had been processed during the same week my grandmother was admitted into long-term care. Melissa contacted the issuing bank branch in Ross County to verify signature authorization. The bank declined to release internal verification records without a court order, but confirmed that no durable power of attorney was on file authorizing Dana to act on the account before death. That did not prove wrongdoing, but it narrowed the explanation. If Dana had acted without legal authority prior to death, the transfer could constitute breach of fiduciary duty once she became executor, and potentially conversion of funds if done without consent. Melissa prepared a motion requesting the court compel production of original signature cards and authorization records from the bank. That filing changed the tone of the case. 2 days later, I received an email from Dana. She wrote that my attorney's actions were unnecessarily aggressive and that family matters should not be escalated into formal litigation. She stated that the reimbursements reflected time and travel expenses she had incurred while managing our grandmother's medical transitions. There were no receipts attached. I read the message twice before responding. I did not argue. I forwarded it to Melissa. By mid-April, the court granted the motion for limited bank record production. A subpoena was issued for signature verification and transaction authorization documentation related to the 2 transfers. Dana's attorney filed a response arguing that the transfers were legitimate reimbursements and that my petition was causing delay in estate administration. That was the first time I saw counsel formally retained on her side. The dispute was no longer implied. It was documented. On April 22nd, I received the bank's compliance packet through Melissa's office. Inside were copies of the original withdrawal forms. The signature on the first transfer resembled my grandmother's handwriting, but was slightly compressed, the loops tighter than usual. The second signature differed more noticeably. The baseline slanted upward. Melissa did not offer a conclusion. She requested a forensic document examiner to review both signatures against known exemplars from prior tax returns and account documents. The cost of that review would be mine to cover initially. I approved it. This was the point where the matter stopped being theoretical. If the signatures were deemed inconsistent, we would move to petition for Dana's temporary suspension as executor pending further review. If they were validated, my position would weaken. I drove back to Chillicothe that weekend to meet Mark and resume limited work that did not interfere with the wall cavity where the lockbox had been found. The living room felt exposed now. Framing visible, wiring labeled. Structures look different once opened. So do families. I did not confront Dana directly. I did not accuse her of theft. I allowed the process to move forward. But by authorizing forensic review of her financial conduct, I had crossed into a space where returning to normal conversation would no longer be possible. The accounting had turned a question into a record, and records require resolution. The forensic report came back on Monday, April 29th. Melissa called me before sending the written summary. The examiner had compared the signatures on the 2 withdrawal forms with verified exemplars from my grandmother's prior tax filings, estate planning documents, and bank signature cards. The conclusion was careful but clear. The first signature showed signs of tracing or guided replication. The second displayed significant inconsistencies in stroke pressure and slant, inconsistent with natural variation in aging. It did not declare forgery as a criminal finding. It stated that the signatures were highly likely not executed by the same hand as the verified samples. That was enough. Melissa explained the next step. We could petition the probate court to suspend Dana as executor pending full review, citing potential breach of fiduciary duty and risk to estate assets. If granted, Dana would lose authority over the estate account immediately. A neutral fiduciary could be appointed to manage funds while the matter was adjudicated. It was a direct escalation. I asked for one night to consider it. That evening, Dana sent a formal letter through her attorney. It accused me of improperly removing estate property from the Chillicothe house and suggested that the lockbox contents should have been turned over directly to her as executor. The letter requested immediate delivery of all original documents to her counsel. Melissa responded the following morning. She attached the Chillicothe Police Department incident report documenting the discovery of the lockbox inside a wall cavity in property titled "Solely in My Name." She stated that the documents would be produced through proper court channels, not informal demand. There was no raised voice, no argument, just paper answering paper. On Wednesday, May 1st, I authorized Melissa to file the motion to suspend Dana as executor. The motion cited 3 points. First, the existence of a later discovered will, naming a different fiduciary. Second, forensic findings indicating probable unauthorized signatures on pre-death transfers. Third, risk of continued control of estate funds by an individual whose conduct was under active review. Once filed, the motion could not be withdrawn quietly. The court scheduled an expedited hearing for May 14th. Notice was served to Dana and her counsel. I drove to Chillicothe that weekend to meet Mark and confirm that we would pause any structural work that might disturb the area where the lockbox had been found until after the hearing. Not because it was legally required, but because I understood optics. Accountability requires clarity. On Monday, May 13th, the day before the hearing, Dana emailed me directly for the first time since retaining counsel. She wrote that I was destroying our family's privacy and that any financial discrepancies could have been resolved privately. She stated that if I pursued suspension, there would be long-term consequences for our relationship. I read it once. I did not respond. The hearing took place in a standard probate courtroom in Franklin County. No jury. Just the judge, both attorneys, and a small gallery. Melissa presented the forensic summary and the bank's confirmation that no durable power of attorney had been filed prior to death. Dana's attorney argued that reimbursement for care coordination was common and that signature variation could occur under stress. The judge did not issue a final ruling that day. He did, however, issue an interim order. Effective immediately, Dana's authority to make discretionary disbursements from the estate account was suspended pending further review. A temporary neutral fiduciary from a local bank trust department would be appointed to oversee the account. Dana remained a beneficiary, but she no longer controlled the money. When we stepped out of the courtroom, nothing dramatic happened. No raised voices, no scene. But the structure had shifted. For the first time since the will was read, Dana did not have unilateral authority over the estate. I had crossed a line by asking the court to remove her control. It was not anger that pushed me there. It was documentation. And once you ask a court to examine your sister's financial conduct under oath, there is no returning to the version of family you had before. The temporary fiduciary took control of the estate account within a week of the court's interim order. His name was Daniel Reeves, a senior officer in the trust department of a regional bank headquartered in Columbus. I met him once briefly in a conference room at his office. He was measured direct and careful not to align himself with either side. His role was narrow: preserve estate assets, review prior transactions, report findings to the court. By early June, he had completed a preliminary internal review and recommended a full forensic audit of the estate account and any related pre-death transfers that overlapped with Dana's involvement. The cost would be charged to the estate unless the court later allocated it differently. Dana's attorney objected, arguing that the prior forensic signature review was sufficient and that additional auditing would drain estate resources. The judge authorized the expanded review. That decision widened the scope beyond 2 signatures. It opened every transaction in the months before my grandmother's death to scrutiny. While the audit proceeded, Daniel required that all estate-related expenses receive written justification and supporting documentation. Reimbursements were frozen. No discretionary transfers were permitted. For the first time, Dana had to request approval to access funds she once controlled outright. The forensic accounting firm retained by the bank began by mapping transaction patterns over a 6-month window. They compared debit activity check numbers, electronic transfers, and ATM withdrawals against known periods when my grandmother was physically capable of visiting a bank branch. One detail emerged early. A withdrawal form for one of the disputed transfers had been processed in person at a branch in Ross County on a weekday morning when medical records showed my grandmother had already been admitted to long-term care. Melissa obtained certified admission records from the facility through formal subpoena, confirming the date and time of intake. The intake occurred at 9:15 in the morning. The withdrawal was time-stamped at 10:42. The branch was a 15-minute drive from the facility. That did not prove who signed the form, but it narrowed the possibilities further. Dana's attorney submitted a written statement asserting that she had transported our grandmother to the bank earlier that week and that memory discrepancies could explain the timeline overlap. The forensic accountants flagged another issue. The memo line for both transfers listed care coordination reimbursement, yet no invoices or mileage logs were ever submitted to the estate file prior to my petition. When Daniel requested documentation supporting those reimbursements, none was provided beyond Dana's written explanation. The audit report filed with the probate court in late June stopped short of criminal conclusions. It did not use the word fraud. It did state that the transfers lacked documented authorization, lacked supporting expense records, and occurred during a period of diminished capacity. The report recommended that the court consider whether fiduciary standards had been breached and whether restitution to the estate was appropriate. The judge scheduled a follow-up hearing for mid-July. Separately, as required under Ohio law when potential financial exploitation of an elderly person is identified in probate proceedings, the matter was referred to the Ross County Prosecutor's Office for review. No charges were filed at that stage. It was a referral, not an indictment. Still, the existence of a prosecutor's review changed the temperature. Dana did not contact me directly after the referral notice was issued. Instead, her attorney filed a motion requesting mediation prior to further evidentiary hearings, arguing that continued litigation would damage family relationships irreparably and reduce estate value. Melissa explained that mediation did not eliminate the court's oversight. It created an opportunity for structured negotiation under supervision. I agreed to participate, not because I wanted to reconcile, but because restitution, if appropriate, would restore estate funds faster than extended hearings. By that point, my renovation loan had fully funded, and work at the house had resumed in phases that did not disturb the original wall cavity. The framing was repaired. Electrical updates were underway. Inspections were scheduled in accordance with city code. I was managing contractors during the week and reviewing legal filings at night. The estate account remained under neutral control. Dana remained a beneficiary. No final ruling had been issued. Nothing had been resolved, but the pattern was no longer abstract. It was charted. And once a pattern is charted in a courtroom record, it does not disappear simply because someone calls it a misunderstanding. The mediation was scheduled for Thursday, July 11th, in a private conference suite, 2 floors above the probate courtroom in Franklin County. It was not a public hearing. There was no gallery, just a retired judge serving as mediator, both attorneys Dana and me. By then, the forensic audit report had been formally entered into the court record. The referral to the Ross County prosecutor remained under review. No charging decision had been announced. The mediator began by outlining the purpose: voluntary resolution, confidential discussion. No binding outcome unless both sides signed. Dana sat across from me, her attorney to her right. She looked composed the same way she had at the will reading months earlier. Structured. Prepared. Melissa summarized the audit findings without dramatizing them. 2 transfers lacking documented authorization. No supporting invoices. A branch withdrawal processed after confirmed admission to long-term care. The September will naming a neutral fiduciary. Dana's attorney argued that care coordination often involves informal expenses, travel, time off work, emergency decisions. He suggested that poor record-keeping did not equate to misconduct. The mediator asked a direct question. If the court ultimately determined that fiduciary standards had been breached, was Dana prepared to restore the disputed funds to the estate to avoid extended litigation? There was a pause before she answered. She stated that she never intended to harm the estate and that she believed the transfers were justified. But she also acknowledged that continued proceedings would create financial and reputational strain. That was the first time the word reputational surfaced explicitly. Her employer had not been formally notified of anything. There had been no public allegation. But compliance officers understand what court records mean. The mediator requested that we break into separate rooms. In private session, Melissa laid out the risk calculation. If we proceeded to full evidentiary hearing, the court could remove Dana permanently as executor order restitution and potentially refer findings more strongly to the prosecutor. The estate would incur additional fees. The timeline could extend another 6 months. If we negotiated now, restitution could occur within weeks. Estate distribution could resume under neutral management. The choice was not about forgiveness. It was about structure and recovery. After 3 hours of back-and-forth proposals, a framework emerged. Dana would reimburse the estate in full for both disputed transfers, including statutory interest from the date of withdrawal and the cost of the forensic audit. She would formally resign as executor, converting the temporary fiduciary appointment into a permanent neutral administration through estate closure. She would acknowledge in writing that the transfers were made without formal documented authorization, without admitting criminal intent. In exchange, I would not oppose closing the matter civilly upon full restitution and would not independently pursue additional civil damages beyond the estate claim. The mediator drafted a term sheet. Both attorneys reviewed it line by line. Dana read the document twice before signing. I signed after her. The agreement was contingent on court approval. Nothing became final that day. But for the first time, the numbers were fixed. The responsibility was quantified. Outside the building, the air felt heavy with July humidity. No reporters waited. No one asked questions. The prosecutor's review remained open. The judge still had to accept the mediated settlement. Funds had not yet been transferred. There was no victory, only movement. What had begun as a question inside a wall was now a signed commitment to repay specific dollars on specific dates. Accountability had taken shape. It was not emotional. It was scheduled. The mediated agreement was submitted to the probate judge the following week on July 18th. Court approval was not automatic. The judge reviewed the forensic audit, the mediation term sheet, and the pending referral notice from the Ross County prosecutor before issuing a written order. On July 29th, the order was entered into the docket. The court approved the settlement with modifications. Dana was formally removed as executor, effective immediately. The temporary fiduciary, Daniel Reeves, was appointed to serve through the completion of estate administration. Restitution was to be paid to the estate account within 30 days, including statutory interest, calculated from the dates of transfer and reimbursement of audit expenses. The order stated that the court found insufficient documentation supporting the pre-death transfers and that the lack of written authorization had constituted a breach of fiduciary duty once Dana assumed executor responsibilities. The language was measured. It did not use criminal terminology, but it was clear. By mid-August, the first restitution payment was deposited into the estate account under Daniel's supervision. A second payment followed 2 weeks later, covering the remaining balance and audit costs. The estate ledger reflected the correction. Daniel filed a compliance update with the court confirming full repayment. Shortly after, the Ross County Prosecutor's Office issued a formal notice declining criminal charges at that time, citing full restitution and cooperation with probate oversight. The letter made clear that the matter had been reviewed under Ohio statutes related to potential financial exploitation of an elderly person and would remain documented in county records. There was no arrest, no courtroom spectacle. There was a written decision. The September will was then addressed. In early September, after reviewing witness affidavits and notary verification, the court determined that the September document met statutory requirements and that the December will admitted earlier had been incomplete in its submitted attachments. The December version was set aside. The September will was admitted as controlling. The brokerage account was recalculated for equal distribution between Dana and me. The certificates of deposit were transferred into a restricted educational trust for our younger cousins, administered by the same bank trust department now overseeing the estate. Dana remained a beneficiary of her equal share. She did not object to the recalculation. Her signature appeared on the revised distribution schedule filed with the court. The house in Chillicothe remained solely in my name as originally stated in both versions. When the updated inventory and distribution plan were entered into the docket, I pulled the record online from my office in Columbus. Every adjustment was listed in black and white. Executor removed, restitution received, will admitted, trust established. The language was administrative, neutral. But the structure had changed completely from the day we sat in that first conference room. Dana's authority had been replaced by oversight. Her discretionary control had been converted into equal standing. The estate was no longer shaped by one person's decisions. It was governed by record. I did not feel relief, not yet. There was still the matter of closing the estate final tax filings and distribution checks to be issued under Daniel's supervision. Nothing was undone. It was corrected, and correction carries weight of its own. The estate closed in late October. Daniel filed the final accounting with the probate court reflecting restitution received, administrative costs paid, the educational trust funded, and equal distributions issued under the September will. The judge signed the order discharging him as fiduciary and formally closing the case. A check arrived at my office in Columbus 3 days later representing my share of the brokerage account after recalculation. It was not an abstract number on a spreadsheet anymore. It was tangible, cleared, settled. The prosecutor's review remained documented as declined for charges. The probate docket reflected removal of executor breach findings, restitution satisfied, and admission of the controlling will. There were no unresolved filings left. In Chillicothe, the final building inspection on the house passed on a cool morning in early November. Electrical signed off, structural repairs approved. The wall where the lockbox had been hidden was reclosed, insulated properly, and painted the same muted tone as the rest of the living room. No plaque marked the spot. It was just a wall again. I met with Daniel one last time before the estate closed to discuss something separate from distribution. I asked about establishing a small revocable trust for myself administered by the same bank's trust department. Not because I expected conflict, but because I understood what unmanaged discretion could become. I allocated a portion of my inheritance into that structure, not as a shield, as a boundary. Dana and I saw each other in September at a cousin's birthday gathering. The conversation was brief and controlled. No discussion of court, no revisiting of numbers. She had transferred the restitution funds on schedule. She had signed the revised distribution. She had stepped down as executor. Those were facts. We did not return to how we had been before. There was no dramatic reconciliation. There was also no public fracture. We existed in a new configuration, separate finances, separate authority, documented expectations. I chose not to sell the house. Instead, I refinanced the renovation loan after completion at a lower fixed rate and converted the property into a secondary residence that I visit on weekends. The educational trust for my younger cousins is administered quarterly statements issued by the bank structured exactly as my grandmother described in her letter. The letter remains in a fireproof file cabinet in my office, not as evidence anymore. As instruction. What I uncovered behind that wall did not make me richer than my sister. It made the structure honest. Inheritance is not only about assets, it is about who holds discretion and whether that discretion is accountable. The house stands solid now. So do the records. If you have ever found yourself holding a document that contradicts the story you were told, consider this silence preserves comfort, but documentation preserves truth. Sometimes the only way to protect a family is to insist that it operate on record.
This story is creative content developed for storytelling and reflection. It does not depict any specific real individuals or actual events.